Okay, I am live. Can you hear me okay?
I can hear you pretty well.
Good.
And let's see, you ready there, Andrew? Okay. The following presentation is the service of ATG Trust. My guest is Tax Law Channel host Rob Wood. We're going to talk today about Federal False Claims Act cases. These involve relators who come forward with evidence of fraud and enter into what is usually a long-term contractual relationship with the federal government, leading to a relator's share. In his article in Tax Notes, Rob asserts that the resulting relator's share in those cases should be taxed as capital gain, not as ordinary income. Please welcome His Eminence, Robert Wood. Hi, Robert.
I'm just trying to recover from being called an eminent anything.
Well, we do so many videos, I just want to break it up a little bit.
That's understandable.
Anyway, these are called Ketan cases, whistleblower cases, and let's begin. This is a pretty long article here, but let's talk about what relator shares and why essentially you're looking at these as capital gains and not ordinary income.
Right. Well, I'd say first of all, I like to avoid the whistleblower nomenclature, and I say that because there are lots of different whistleblower statutes, or lots of different statutes that pay an amount to someone for bringing something forward or finding something. There are all sorts of award and reward and whistleblower provisions. But I want to stress that I'm focusing only here on the Federal False Claims Act, which I guess despite my reticence on using the whistleblower nomenclature, a lot of people do refer to it that way. I, though, like to use the term which is unique to the Federal False Claims Act, and that is relator. Relator, as you say, it's a funny kind of a term, but it's basically the person who comes forward and who turns over the information to the government. I'd say, and you're right, this is a bit of a long article. I can only tell you that it was originally twice as long. So I guess everybody gets edited, myself included. But what I'm trying to do is to point out the historical roots of this law, which kind of surprised me, go all the way back to the Civil War. And so fraud against the U.S. government in government contracting is sadly nothing new.
So I guess when we talk about then how the tax treatment affects these relator shares, I guess we can talk a little bit about the beginning here. Secret information, know-how and patents, and how all that relates.
Right, and yeah, thanks. The basic provision, and I go through the statute and then try to relate it to the tax authorities. Obviously, the Federal False Claims Act doesn't have anything about taxes in it. It is again a long-standing law which was revised a few times and is in the news a lot these days because of people getting some very large recoveries. But essentially, the relevance of patents and secret information, know-how, trade secrets, is there's a pretty significant body of federal income tax law regarding how those items are taxed. So that if, and patents are probably the easiest of one to describe because there's a special code section, section 1235 of the Internal Revenue Code. That one applies only to patents, and so I guess it's irrelevant to this discussion. But on the other hand, in many of the non-statutory cases involving other forms of intellectual property, such as trade secrets and know-how, and these are doctrines that emerge from the common law, secret trade information that are that have been taxed as capital gain in the past. So what I did was to try to look at what happens in a Federal False Claims Act and what information is actually transmitted to the government, because it is the government's claim to recover for fraud, and the relator then gets a share of that, which in my view as I've argued in tax notes, qualifies as trade secrets or know-how or both, and therefore would be capital in nature. Obviously, why is this relevant? That should be obvious to anyone. The current capital gain tax rate of 15%, obviously that's not going to last very long, but the current rate versus the current ordinary income rate approaching 40% is pretty big differential, and if you were sitting on a recovery that was coming in, you would care a lot about which tax rate applied.
You also state that we could expect the IRS to argue that a relator's share represents a right to future ordinary income, and then would be treated as such. And how do we get around that? What does the IRS really think about this?
Yeah, well, I think there is no case yet, as I point out. But the future ordinary income is, there actually is a doctrine called the substitute for ordinary income doctrine, which in tax cases has been applied, for example, to people who sell a stream of lottery payments. I mean, factually, it's very, very different from this kind of a case, but there are authorities certainly out there that that need to be distinguished. I would say one other important thing here is that the government could well argue this is really like performance of services. That what's really important is the relator stepping forward and saying, I saw this fraud, or I'm aware of this fraud, and sort of giving testimony. And is that services, or is that providing the information? Sort of which is predominant? I would just say that if you read sort of a mixture of the tax cases dealing with trade secrets and know-how on the one hand, and the Federal False Claims Act cases dealing with sort of the size of relator shares, because there's some gradients there. I think my conclusion is right, but it's certainly not one that's free from doubt.
Well, it's a really good article, footnoted as much as could possibly be. Yeah, I mean, you're really going into some great detail here, and your conclusion is pretty solid. I wish we all could have some kind of in-hand case so we could test it out.
I agree, and as I say, I don't know. I mean, these days the cases are lots of cases in the press involving pharmaceuticals and medical care, that kind of thing. But the ones that I always think about are whatever happened to the $10,000 toilet seats and the $30,000 screwdrivers and things like that were so much in the news in the 70s and 80s.
My guest is Rob Wood. He is the host of the Tax Law Channel. He practices tax law in San Francisco. You can also find him at woodporter.com. This has been a service of ATG Trust. Rob, thanks for taking the time to talk with us again today.
Thank you, Scott.
This is Scott Drake, and you're watching the Legal Broadcast Network. Because it seems like, I guess the sticky part here is where the government says, well, we kind of got a contract with you.